In this connection, the opposite party BDO filed affidavit. They filed the affidavit on 23/9/2021, and in pursuance of that affidavit, they have done nothing. And in this connection, my humble submission, I have filed one IA for appointment commissioner at the cost of petitioners, who will visit to the spot and submit a report before this honorable court. Whether
18th August 2021 required the opposite parties to file a implementation of the recommendations made by the Principal Secretary Panchayat Raj and Drinking Water Department, Panchayat Raj and Drinking Water Department. Pursuant thereto, 2021, stating that,
my lord, by giving prior notice to the collector and BDO,
he will proceed after the collector and the Tahsildar.
I think BDO
And the BD Secretary DLSA Bhadrak to be submitted to this court on or before 21st November 2022.
That the order may be communicated to the collector.
The copies of the report of the
this order.
That one. Copies of the report of the secretary with its enclosures be provided to counsel of the petitioner as well as counsel of the state by the registry as soon as it is submitted, to enable them to make submissions on the next date.
Item number 2 and 3 have just received the counter.
All right.
In court. Lord, I was just humbly praying, Lord, keeping the urgency of the matter, my Lord. This is, my Lord, relating to an inverted tax duty, my structure, my Lord.
and that hearing the sound, myself and mother came running to the spot. It's not a fact that I didn't see anything else and deposed falsehood. Well, Peter well is the doctor. That was he has conducted autopsy on Anand Mahapatra. You're asking, that is page 82. Page 82 plus.
Yes.
And page 79, your lordship will get the doctor who has examined the other disease, Thakur Mahapatra.
Anyway, I
Your
don't
lordship,
think
kindly
they're
appreciate the
not
nature of
questioning all
injuries.
this.
Yes,
They are not questioning all this.
yes, ma'am.
This corroborates the homicidal death.
Minus. And also it corroborates the FIR story also.
Correct, correct.
And plus regarding medical evidence statement. And PW 16 is the doctor who has examined Kamini Mahapatra plus at page 91.
Yes.
The injured. Page 91, PW 16.
Correct.
Just for a moment, I am going to the evidence of the IO. You'll also the IO's evidence starts from page 93 to 108. He has even not confronted regarding the contradiction that the defense wanted to draw from the evidence of PW. Both the injured eyewitnesses were been examined as PW 11 and 14. And defense witness has been examined as DW1, that is rather supporting the prosecution or the defense. And here is a murder of two persons, only it is for rupees 42. He said, yes, it is only 22, not 42. For that reason, one person has been murdered, and subsequently the other person when came to rescue her, then also he has also been murdered. This is brutal in that way, and degree of criminality is quite high in this case. And there being substantial materials, there being evidence of injured eyewitness, because there are injured eyewitnesses, the very injury caused to the injured eyewitness that ensures their presence at the spot of occurrence. That is the reason why the evidence of injured eyewitness are valuable and more reliable. And when the evidence of injured eyewitnesses are corroborated by the medical evidence and so also corroborated by the FIR loss. So the prosecution has successfully proved the case against all these accused persons. So the judgment passed by the trial court need not be interfered with.
All right. Orders reserved. It will be open to the parties to file their respective written notes of arguments within 1 week.
Diploma.
All right.
Supplementary list fresh admission item number 1, ARBP 71 of 2022.
On behalf of Sunil Kumar Panda, kindly take up this matter next week.
Wasn't this mentioned and listed? Huh? It was mentioned yesterday for listing.
The senior is in problem. That's why he told me on telephone that to urgent the matter, my lord.
Yesterday it was mentioned and listed today. You are appearing for the petitioner.
Yes, my lord.
What is the prayer, sir? This is not section 11. Appoint an arbitrator, ask him to take over the firm. What is this?
I don't have the.
What is
file
this
with
prayer? You're combining everything. Pass an award, direct the opposite party to pay. This is not a section 11 prayer at all, sir. What is this? And restrain the opposite party by way of injunction under section 9. Everything. Omnibus. You see, from a reading of the prayer of the present application, it appears that several reliefs are all being jumbled together. And it is not reading as a prayer exclusive to section 11 of the Arbitration Conciliation Act 1996, permitting the petitioner to file a proper application in accordance with law. The application is disposed of.
For orders item number 2.
Come to the small errors in the cause title, sought for modification, because at the end of the, while typing out the judgment, that CMD has been inadvertently written instead of Manhadi Coldfields.
I see. All right. For the reasons stated therein, the application is allowed and the modifications are straight for
My name may be read.
yes, yes, and his name also be shown. All right.
Item number 3.
My lord, I am for the petitioner. I would, Mr. Nyamati, the London Council was appointed as the arbitrator.
Yeah, he has declined. All right.
Mr. Nyamati, the London Council was
I
appointed
know.
by.
He has declined, sir. He has declined. Right.
Yes, my lord. I would suggest the senior advocate, Mr. Manoj Mishra.
All right. Mr. Niyamati has declined to act as an arbitrator. Accordingly, the court appoints Mr. Manoj Mishra, senior counsel.
My lords, I appear for the respondent.
Yes.
May a neutral arbitrator may be appointed from the panel instead of the name suggested by.
All right, Mr. Padi,
Yes, my lords.
senior advocate. Mr. Padi, senior advocate, be appointed as sole arbitrator to adjudicate the party between parties. The arbitration will take place under the aegis of the arbitration sector. All right.
For admission item number 4.
Yes, madam. Yes.
Done, finally.
Yes, finally
Okay.
done, and I am filing an affidavit to that effect. Your
Okay.
lordship may reflect this in your lordship order.
All right.
One just request your lordship, my lord, kindly see there's an authorization filed by the lord, so affidavit. That authorization, your lordship may kindly indicate in the order that that person is authorized to swear this affidavit.
All right. Learned counsel for the petitioner has placed on record an affidavit of Shri Dilip Kumar Patihari, working as senior manager, Godrej and Boys Limited, Manufacturing Company Limited. Dated 4th November 2022. Learned counsel states that Mr. Patihari is duly authorized to swear to the affidavit. Full stop. The affidavit records the terms of settlement of the dispute between the parties. The affidavit is placed on record and is made part of this order. Full stop. The petitioner states that in the affidavit that in view of the amicable settlement, the petitioner does not want to proceed further in the matter and accordingly seeks to withdraw the present petitions. You say the petitions are disposed of as withdrawn in terms of the affidavit filed by the petitioner. The parties will be bound by the terms of settlement as set out in the affidavit.
Rest of the matters.
Rest of the matters, same order. The
Same
numbers
order.
are
I have
mentioned in
indicated
para
the
2.
affidavit.
Lordship may kindly indicate that. The numbers are mentioned in para 1 itself.
We'll put all the numbers together
That's right.
and a common
That-
order
that
in all
would
the
do.
matters.
That
Right.
will, that
Right.
grateful.
Item number 4 to 8. Item number 9.
In the counter, they say that they say that there's a settlement clause which we have not availed of. We have in fact availed it, and the arbitration center rules also have a provision for settlement within the arbitration. So if they are really wanting settlement, they can always do it before the arbitrator.
Who's for the last time also nobody appeared?
Uri municipality.
Yeah.
Page 27 of that rules, internal rules.
Right.
There's also a settlement provision in the center also allows it within the domain of the arbitration.
Although Mr. P. Mohanty, advocate, had appeared before this court on behalf of the opposite parties on 4th March 2022 and had sought time for filing a reply. No, had sought time for filing a reply, full stop, pursuant thereto. An affidavit has been filed on 27th October 2022. Where there is no dispute, where there is no denying the fact that there is an arbitration clause in the agreement between the parties. Full stop. However, it is sought to be contended that the arbitration petition is premature since the agreement provides for a dispute resolution clause under which the parties should first try to mutually settle the issue through negotiation. Paragraph. However, in the present case itself, it is seen that on 30th September 2022, counsel for the opposite parties informed the court that they were interested in settling the matter, and they had called the petitioner to meet them with documents. Full stop. Even then, Mr. Gautam Mishra and senior counsel for the petitioner had disputed the submission. Full stop. Nevertheless, this court had adjourned the matter to enable the parties to settle the disputes. Full stop. Paragraph. On the next date, that is 28th October 2022, none appeared for the opposite parties. And Mr. Mishra also informed the court that till date his client had not been called for any settlement, negotiations or settlement. Paragraph. Today again, none appears for the opposite parties. Full stop. It is clear, therefore, that the attempts at settling the disputes between the parties, even in terms of the aforementioned clause in the agreement, has not materialized. Paragraph. With there being no dispute about the existence of an arbitration clause and of there being disputes between the parties arising from the agreement in question, the court proceeds to appoint. What's the claim amount?
3 crores 68 lakhs.
Justice Vishwajit Mohanty.
Which may appoint Justice Rath.
All right, Justice Dr. A.K. Rath as sole arbitrator to adjudicate the disputes between the parties, including the claims and counterclaims.
Just 2 things, if my lords can indicate. In the notice invoking arbitration also, we have said that settlements were not fruitful.
That's all right. Anyway, that's a...
And that clause in the center, that if they really want, settlement is also present.
That can always be urged before the arbitrator. They should appear, only then we can...
My lords, we only apprehend that they may say, take it higher, because we don't know. They may take it to the Supreme Court.
Let us, you can point out there.
My lords.
The arbitration will take place under the aegis of the arbitration. All right.
We are grateful.
Item number 10.
As item 10, my lords, I'm appearing for OP number 1. We have
Yes.
filed a counter. There's a rejoinder filed by, by the petitioner. We have not been served with a copy of that rejoinder, my lords. It may be served. Your lordships may take it up next week.
Worship, I'm appearing on behalf of the petitioner, Worship, on behalf of Mr. Bhaupashran Bera. I will serve the rejoinder in the meanwhile, as Mr. Bera has met with an accident and have undergone for a surgery. Worship, please to keep this matter after 2 weeks. In the meanwhile, I will file the rejoinder.
Copy the rejoinder be served on counsel appearing for respondent number 1.
Yes, my lord. And we are filing our counter today, my lords.
Whose counter is taken on record. Yes.
Deeply obliged, my lords. Deeply obliged.
List on. 9th December.
Deeply obliged, my lords. My lords, counter copies also we have given to Mr. Mishra.
All right.
Yes.
Item number 11.
Please, your lordship. I have already received the Parvai's comment.
May I
and
please,
I
your
prepared the counter. Only 1 week time may be granted your lordship to file the counter, because here in this case there is an arbitration clause. Before there also conciliation proceeding, resolution method proceeding is there. That's why the counter is necessary to be filed. Only 1 week time. I've already received the Parvai's, your lordship. I'm preparing the counter.
Counsel appearing for the opposite party states that he will positively file his reply within a week, rejoined if any before the next date. 9th December.
My lord, deeply pleased.
Item number 12.
It's item 12.
Yeah,
and
last
13.
occasion they had issued some, Milords was appointing. My learned friend said we need some instructions. I don't think anything left. I have followed the procedure in its entirety. Justice Pujari, I suggest Milords may be appointed.
Just one. Whereas the scheme also envisions a conciliation, which is adjudicator. My lords.
I have gone to the adjudicator, Milords, that is there on the record, and he has not taken any
My
action.
lords, may kindly hear me. Since that adjudication process, my friend is right, he had initiated, nothing has happened, my lords. 22/4/2022, this year, my lords, he had sent for adjudication. My humble submission is, if my friend is, both parties can sit before the adjudicator. Otherwise,
Sit even before the arbitrator, sir. If you are willing to settle, you can settle even before the arbitrator.
Justice A.K. Mishra.
I have no objection.
All right. With the consent of both parties, Dr. Justice A.K. Mishra is appointed as sole arbitrator to adjudicate the disputes between the parties, including the claims and counterclaims. The arbitration would take place under the aegis of the arbitration center. These all petitions are disposed of. All right.
Item number 13.
Same, Milords.
Same,
Milords.
All right.
This will be serial.
All right.
Special list fresh admission item number 1, CRLNC 926 of 2016.
Permitted to be withdrawn. Right. Dismiss as withdrawn.
Item number 2,
None appears dismissed. Interim order is vacated.
item number 3,
None appears dismissed. Interim order vacated.
special list item number 4,
None appears dismissed.
item number 5,
None appears dismissed.
item number 6,
None appears dismissed.
item number 7,
OP2 for appearing. For OP2, my lord. None appears for the petitioner, dismissed non. This interim order is vacated. Same the second matter.
item number 8,
May I please, your lordship? My lord, the present application involves the quashing of proceeding against the petitioner. Here is the case, my lord. On 6/3/2013, my vehicle has been seized by the forest officials. And thereafter, PR submitted against the petitioner along with the driver of the vehicle. Your lordship, kindly turn to page 6. My lord, my submission before your lordship, I am entangled in this case only mere owner of the vehicle. No presence at the spot, nothing else, my lord.
And where is the vehicle now? What is the
Vehicle has
vehicle?
been seized. Vehicle has been seized by the, my lord, forest officer.
No, what is the vehicle?
Vehicle, my lord, is a lorry, my lord.
Lorry.
Lorry.
And it is now, where is the lorry now?
My lord, that has been seized by the forest officials and hand over to the police, my lord.
No, where is it? Where is the lorry?
Now under seizure, my lord.
No. The last 6 years, the lorry is standing outside the police station.
Yes, my lord. And
No.
my prayer before our lord.
No. When was the lorry seized?
Seized, my lord, on 6/3/2013.
Last 9 years, the lorry is still standing there.
My lord.
I 100% sure certain.
My lord.
This is right.
And my lord, here is the present case.
I have to take instruction.
Mr. Katke will take instructions on the current position of the lorry which is supposed to have been seized more than 9 years ago. That is request list before the roster bench on 7 December.
Interim order continue.
What interim order, sir?
Interim order, my lord, protection, my lord, not to arrest the present petitioner. My lord, the present petitioner
Between
is
now
ready.
and 7 December, if they arrest, you move an application. Yes.
My lord.
Item number 9.
None appears dismissed. Interim order vacated.
Item number 10.
On last occasion, your lordship, direction given to state government to take instruction, my lord.
Sanction, same problem. Was sanction given or not?
Yes, yes. Latest, latest instruction had not come. Because last time. it was-
Can't go on adjourning, sir. The
On
matter was
14th.
adjourned on 14th October 2022
Yes.
to enable the state to,
Because
the
it
state
was
council to
instruction,
inform whether sanction been accorded.
No. Sorry.
We'll presume it's not been accorded, sir.
Yes.
Even today, the instructions have not been forthcoming. Paragraph, the court is left with the impression that the state government is not interested in according sanction for prosecution of the petitioner. Full stop. Admittedly, the cognizance was taken of the offences against the petitioner, who was a government servant at the relevant time, without sanction having been obtained. To stop on that short ground, the impugned orders dated 25th October 2005 of the JMFC, Damnagar.
That's one whole instruction that, of course, they have tried to drop the proceeding of the petition. The whole instruction was September 2016.
No, but nothing on sanctions, sir.
Yes. Last one line I lost.
Drop the petition. Drop this. What's that meaning? It's a question of dropping the petition. Either we dismiss or allow the petition. In GR case number 1231 of 2005. And all proceedings consequent thereto are hereby quashed. The petition is disposed of.
Item number 11.
May I just seek your lordship small indulgence, not in item number 11. In those arbitration matters, Lord, can I just request your lordship, a free copy of your lordship's order be given to me so that we can expedite the matter, because matter is settled. They are insisting for payment.
Right.
Now, unless we give that order to the university.
Yeah, you get it today itself.
Just a free copy of your lordship's order be given to me so that.
It will be uploaded today.
Right.
And the item 11, my lord, the order of framing of charge, my lord.
So you seek.
As your lordship.
Counsel, the petitioner seeks leave to withdraw the present petition with liberty to urge all the points raised in the present petition at the appropriate stage in the trial court. Disposed of is withdrawn with liberty straightforward.
Item number 12.
None appears dismissed.
Item number 13.
Same order.
Item number 14.
Same order.
Please, my lord. My lords, in item number 14, my lords, in this I'm praying for some time. Mr. Pujari used to appear in the matter, who is no more. After his death, it is getting listed for the first time, my lord. So I'm praying for some time to get instruction in the matter.
All right, at the request of counsel, the petitioner. List before the roster bench on 12th December.
Item number 15.
Grateful minutes.
Item 15.
None appears dismissed.
Item number 16.
Same order.
Item number 17.
Same order.
Specialist item 18.
Permitted to withdraw, my lord.
Counsel the petition seeks leave to withdraw this petition. Dismiss this withdraw.
Item number 19.
May I please ask? Lord, as regards the petitioner number 1, it doesn't survive because he has died in the meantime. 1. As regards 2, my lord, here I'm praying for quashing of the second FIR. In fact, I'm not seeking quashing. My lord, here what has happened in a series of acts constituting a one transaction, 2 FIRs have been lodged, 2 charge sheets have been filed, and I'm being tried in both the trials. So I pray here that the second FIR be or the second charge sheet be treated as a preliminary additional charge sheet in the first one, and I be tried together. In fact, if your lordship would see on the last occasion, your lordship has directed the state to file the charge sheet, my lord.
It's a 302 case, sir.
Yes, my lord. My lord, if my lord would go through the charge sheet in both the cases, my lord would find that it is a case of a series of transactions acts constituting one transaction, my lord. If my lord, I would highlight the allegations in the first FIR. My lord, the first FIR is Chawliaganj Police Station case number 12 of dated 18/1/2016, which corresponds to GR case number 113 of 2016.
Trial must be in progress now.
My lord, trial is going on. But my lord, for the one act, I am facing trial in both the cases, my lord. That's not impermissible under law, my lord.
And I have taken it to the approach stage, sir. If you go and appeal, you can take up all that.
But my lord,
The trial court itself will consider that, sir.
yes. My lord, give me that liberty that trial court would consider if both the
Obviously, any submission that you have, you say, as far as petition number 1 is concerned, his statute of expired on.
Exactly.
Statute of expired. The petition, as far as he's concerned, abates. Paragraph. As far as petition number 2 is concerned, the court permits the petitioner number 2 to raise all the pleas raised in the present petition at the appropriate stage in the trial court. No further orders are called for at this stage. The petition is disposed of. All right.
Item number 20.
None appears dismissed.
Item 21.
Same order.
Item 22.
Same order.
Item number 23.
Same order. There is the same anywhere.
Item number 24.
24, lordship permitted to withdraw, lordship, and to raise all the points in the court below.
All right. Permitting the petitioner to raise all the pleas, the appropriate stage. Interim orders. Right.
Item number 25.
My lord, in item 25, I am for the opposite party informant. They challenge at the stage of investigation.
Anyway, nobody is appearing, sir.
Today morning, I have taken instruction. It has ended in final report and a protest petition has been filed, which is pending. So this has become infructuous.
Infructuous. Counsel for the informant states that a closure report was filed against which the protest petition has also been filed.
Which is pending, ma'am.
Which is pending. Accordingly, the petition is disposed of as having become infructuous.
Deeply.
Specialist for orders, item 26. Item number 26.
None appears dismissed.
MSc.
I know.
Item number 27.
None appears dismissed.
Item number 28.
I will raise all the issues before the court below, my lord. Well, raise all the issues before the court below.
All right. Permitting the petitioner to raise all the
Liberty
issues.
given.
Yeah.
Yes, sir.
The petition is disposed. Right.
Item number 29.
None appears dismissed.
Specialist item 30. Steps. Item 30.
So provision of law is to be furnished to us.
Anyway, now it's been converted into a criminal.
Yes, criminal revision.
MC. Yeah.
No, your hospital can convert it to a criminal revision.
All right. Whatever it is. What is the order dated 24/4/2013?
That is
Three 302.
Maybe call some other. Of course, I don't have the file of that.
Mr. Katkia states, at the request of Mr. Katkia, learned AGA, list before the roster bench on 14th December.
Item 31,
None appears dismissed.
item number 32,
None appears dismissed.
item number 33,
May trigger also. In fact, I had taken instruction from the party. Yesterday, the matter was there before the learned court below, and the learned court below has granted 3 months' time awaiting the status of the case before the reasonable court. Here, my lord, what has happened? I instituted a complaint petition.
But the opposite party number 7 unserved.
What I am praying for, my lord, since the learned trial court has yesterday granted 3 months' time, if your lordship permits me, I can take notice by speed post.
You can take
Notice by speed post to those parties.
what is
Because here your lordship will see there is an apparent error. If I cannot demonstrate that, I have to fail. My here what has happened, a complaint was filed alleging commission of offences under section 341, 323, 325, 294, 506 Roman 2, 379 read with section 34 of the IPC. Now, my lord, so far as this cognizance is concerned, the court has to apply its mind. The court has said he has perused the complaint petition and the statement of the witnesses. If apparently the statement of the witnesses, which are in English, my lord, and I have annexed, shows that he has taken cognizance of only offences under 323 and 294. My submission is, my lord, the statement of the witnesses which I have annexed clearly discloses offences under section 341, then 5062 and 379. That has been ignored. All the 3 witnesses have consistently said that they took away the Nokia mobile phone and 1,000 rupees. That makes out a case of 379. Then the threat with knife is there, which makes out a case of 506, your lordship. And this 341 also wrongful restraint is apparent. So therefore, when the court says that it has perused, it has definitely not applied its mind. Your lordship may kindly see the impugned order at page. Then I will just show to your lordship the statements. Your lordship will kindly see the impugned order at page 18. I'm sorry, my lord, I have a sore throat.
right?
Page 18, your lordship, the learned court below says,
The record is posted today for order.
peruse the complaint petition, deposition under section 200 CRPC, inquiry under section 202 CRPC, and all other materials therewith. I hold that a prima facie case is made out against the accused person since cognizance of offence under section 323, 294 read with section 34 of the IPC is taken. My grievance is, now your lordship may kindly come back to the statement which he has perused. The statements at page 12, your lordship. Your lordship, this is the initial statement of the complainant under 200, my lord. Page 12, paragraph 3, my lord, 5th line from the top. They detained me and abused me, saying so and so, and Sasmita and Niyati caught hold of my hand. Then Panchanan and Benundhar assaulted with lathi. Premalata and Vijay showed me knife and bhujali and threatened me. Madhusudan, they pressed my neck. Dhananjay took away my Nokia mobile set. Bapi Rao took away rupees 1,000 from my shirt pocket and slapped me. Then your lordship may kindly see the next statement, page 14. My lord, paragraph 1, subpara 2, line number 2, your lordship. When I reached the spot, accused persons were assaulting the complainant by means of lathi. This is an independent witness. Accused person threatened the complainant with dire consequences. I came to know the accused persons from the complainant when I had, then he interfered. Then your lordship may kindly see page 15. Para 1, subpara 2. On 19/8/2015, I had been to so-and-so Hato for marketing at about 4 p.m. I heard hula. When I reached the spot, the complainant was surrounded by the accused persons. That is wrongful restraint, your lordship. Suddenly, accused Niyati and Ananta held Ramchandra Badei hand, and the other accused persons assaulted him by means of a lathi. They abused him in obscene language. 294 is already there. Accused Pramananda and Vijay threatened to kill him by holding a knife. Accused Dhanaja snatched away Ram's phone. Accused Bapi Raut slapped and snatched away rupees 1,000 from him. So what I humbly beg to submit, apart from 323 and my lord, the 294 which the cognizance has been taken, at least leaving aside 325, but 325 has to be by dangerous weapon and assault causing grievous hurt. The other offences, namely, my lord, 341, 379 and 5062 are clearly made out. If he has perused, he has not applied his mind. This is my humble submission for your lordship's kind consideration.
You say fresh notice be issued to opposite parties. Opposite party number 7. What about the others?
Others, my lord, possibly sufficient, therefore there is no noting, subject to correction, my lord.
No, opposite parties 4 and 5 it says something. Received. All right. You say, yeah, none appears for opposite parties 1 to 6, 8 and 9 despite service. Only notice to opposite party number 7 has been returned unserved with a remark, no such address in Badas village. So returned to the sender. Court. Counsel the petitioner undertakes to serve opposite party number 7, Dasti. Before the next date. You are there for the other respondents.
Item 26. But the interim order was there, may kindly be extended.
Interim order to continue.
Deeply obliged.
List before the roster bench on 15 December.
Deeply obliged.
Item 34.
Kindly be permitted to withdraw, my lordship.
Counsel the petitioner seeks leave to withdraw the memos taken under court. Disposed of his withdrawals.
Item number 35.
Item number 35, my lord. Kindly see the annexure 4, page 21. The dispute between the parties are settled. As per their mutual agreement, husband petition number 2 has paid 3 lakhs to his wife towards her permanent alimony, which was already received by this wife for petition number 1. She shall cooperate in disposal of dowry torture cases filed against the petitioner. This is the order dated 6/12/2014, and cognizance has taken order dated right. 15/9/2015.
Why can't you get an affidavit of hers? File an affidavit. You can't, without an affidavit of the opposite party number 2, we can't quash, sir.
Let it come any other day.
No. Do you have? Are you in touch with the respondent number 2? Or are you simply asking like this? Then you produce that before the trial court. That's better. Permitting the petitioner to raise all the pleas urged in the present petition at the appropriate stage in the trial court. The petition is disposed of, the interim order is vacated. All right.
Item number 36.
None appears dismissed.
Item 37.
None appears dismissed.
Item number 38.
None appears dismissed.
Item number 39.
None appears dismissed.
Item number 40.
None appears dismissed.
Specialist item 41.
Wait, please, my lord. I'm appearing on VC on behalf of Mr. Debashish Panda.
Yes.
My lords, the notice is that the notice served has been refused by the opposite party, my lords. It may be deemed sufficient.
What's the matter about?
It is against the questioning of it is arising out of a complaint case for questioning of order of cognizance. Again,
Under what provisions?
under 498A. (498A) 323 read with 34 IPC and section 4 of the Dowry Prohibition Act and against the petitioner number 2.
Yeah, but in the absence of any settlement between the parties, it's not possible to do that.
Because the opposite party has refused to accept the notice.
That's all right. Doesn't mean that's an implicit acceptance of all allegations made in the petition.
Because the notice may be deemed sufficient.
Are they still married? What is it? What is the development?
I need to take instructions in that.
No. You should know.
Because one date may be given to us. We'll seek all the necessary instructions.
Counsel, the petitioner needs time to seek instructions on the current status of the case.
Interim orders to continue.
Yeah, interim order to continue list before the roster bench on 13th December.
Deeply appreciated.
Item 42.
None appears dismissed.
Item number 43.
None appears dismissed.
Item number 44.
None appears dismissed.
Item number 45.
None appears dismissed.
For admission, item 46.
Your Lordship, I'm appearing for Your Lordship. I'm the law officer on behalf of the appellant company. Your Lordship, on the last occasion, an adjournment was sought for engagement of a senior advocate. As per the instruction, appearance memo has been filed on behalf of learned senior advocate P.K. Mahanti. However, due to some personal difficulty, he is not.
This is a 20-year-old case, sir. This is
yes,
a 20-year-old case. We can't keep adjourning like this.
So one last opportunity may be given.
No, it's a 20-year-old case. Last time it was adjourned.
So one last opportunity.
No, sir. Sorry. Not in a 20-year-old case. These kind of cases become a whole burden to the system. And you should not presume that the court is going to grant an adjournment. So please don't be under such impression.
So then we will file a written note of submission in this case that may be allowed.
All right, written note of submissions be filed within a week. Orders reserved. All right.
Obliged from this.
Item 47.
47, Lordship, grant me liberty to raise all the points.
All right, permitting the petitioner to raise all issues at the appropriate stage. All right.
Item number 48.
48, Lordship, when the petitioner challenges the cognizance order taken by the learned SDGM, here the offense may Lord 377, 294. 293 and 506 of IPC, and the FAL Lordship Annexure 1, absolutely there are no allegations so far the petitioner is concerned, Lordship. The supplementary charge sheet, I was submitted charge sheet against the petitioner and master to cognizance. Lordship will go through the affair. The specific allegation, page 11, the specific last paragraph, the informant had categorically stated. So I would therefore request you to kindly apprehend accused Chandrasekhar Chaudhary, son of Harinath Chaudhary, to take stringent action under provision of IPG immediately. This may kindly be treated as the affair which shall be registered and action deemed proper be taken. The specific allegation against Chandrasekhar Chaudhary In first instance, the Charge Lordship may order kindly peruse the order dated 22/1/2013 till mastered to cognizance against Chandrasekhar Chaudhary, and subsequently later on the IO submitted supplementary charge sheet dated 8/7/2013. The cognizance has been taken against the petitioner.
So what is wrong with that? Maybe they've got information against you. So that's what-
Petitioner is the teacher, one of the staffs. The petitioner along with other staffs also made a complaint against the main accused before the informant. My lord, here is the case, my lord, the main accused is the principal. And my learned friend client and my client is the teacher, mere teacher. Though the teacher not taken action against the principal, that is the allegation, my lord. And all the allegations against the principal, Chandrasekhar.
All these are matters to be taken in trials,
And
not here.
No, Lordships, what happened here, my lord, initial allegations, the police already, my lord, discharged from the liability the teachers.
So
And
what was the age of the child? This was a male child, correct?
Yes, my lords.
yes.
How old was the child?
He was a minor, that is, my lords, the
14 years.
my lords, page
14
30,
years,
please.
yeah,
Yes,
all right.
Page 30.
These are matters for the trial,
Yes,
sir. The court is not at this stage inclined to interfere.
Liberty, Lordship.
Yeah, in the matter, permitting the petitioner to raise all pleas at the appropriate stage in the trial court. The petition is disposed of, the interim order is vacated.
My lord, I am appearing, my lord, CRLMC number 3649 of 2014.
All right, in each of these matters, same order. Correct. Interim order is vacated.
Item 49.
49, Lordship, here in the case, the petitioner and the informant are married and now staying happily. Last occasion, Lordship directed to file an affidavit. Both the petitioner applied for registry marriage certificate. The certificate will be issued today. So I am praying the next Friday, I will file affidavit along with the registry marriage certificate.
All right, at the request of counsel, the petitioner, who states that he'll be able to produce the marriage certificate on the next date. List on 9th December. Lordship.
Interim order to continue.
Interim order to continue.
Item number 50.
Not 50, my lord, on the last occasion has directed the state to take instruction regarding the status of investigation. As far as my instruction is concerned, my lord, the investigation has ended in a closure report.
So nothing.
So we have the closure report.
According to the counsel to the petitioner, the investigation has ended in a closure report. The petition is accordingly disposed of as having become infructuous.
Oblige.
Item 51.
None appears dismissed.
Item number 52.
None appears dismissed.
Item number 53.
I mean, pardon, my lord. In a proceeding under section 145 of CRPC, the present petition's application for intervention having been rejected, the present criminal investigation has been filed. Let my intervention be allowed. Thus, criminal investigation may be targeted, my lord. My application.
You are for?
I am for opinion number 6, my lord.
You have any objection to the prayer?
We have no instruction in this matter.
All right. Counsel for appeal for opposite party number 6 states that he has no instructions. Nobody is appearing to oppose the prayer in the present petition, that the petitioner should be permitted to intervene in the proceedings in CMC number 940 of 2014, pending the file of the ADCP cum Executive Magistrate Bhubaneswar, which was stayed with this court on 18 May 2016. Paragraph. Since there is no opposition whatsoever to the prayer in the present petition, it is allowed and the petitioner is permitted to intervene in the above case. To stop, the interim orders accordingly vacated. The matter will now be listed before the ADCP cum Executive Magistrate Bhubaneswar on 12th December 2022, and shall full stop. The said ADCP cum EM is requested to proceed with the matter as expeditiously as possible and dispose it off within a period of 3 months thereafter in accordance with law.
Yes,
the petition is disposed of.
Item number 54.
Well, item 54. In this case, I am challenging the cognizance taken against the petitioners who are publisher and editor of a Daily Samba. In the meantime, the opposite petitioner 1 has expired, and only the petitioner 2, who is the editor, I am pressing against him for him. But the cognizance taken in answer 2 at page 19, at page 20, the cognizance has been taken under section 500, 465 and 469. And the allegation, this was arising out of a complaint case. The complaint case, I filed it as Annex 1 at page 9. And the complaint case was filed against the publication of an article in Delhi Sambal. That is at page Annex page 18. And since this is in Odia, I have translated it and giving a copy to my lord. This is not a news item, it is an article at page 18. I had a personal relationship with Janaki Babu, who was the ex-chief minister, for more than 4 decades. In 1982 at Indupur, in Kendrapada block, 4 persons were murdered in one house. This incident created sensation throughout the state at that point of time. After investigation, police was not getting proof of the said murder. My house is in the area of Nikirai near Indupur. I was writing off and on regarding this incidents in Samaj. One day I met Chief Minister Janaki Babu and said, "Sir, police is not able to conduct investigation of this murder. You should direct the crime branch for investigation." Having heard this, Janaki Babu said, "Parikita Babu, you need not worry. I will take right steps on this." Next day, I read in the newspaper that state government has directed the crime branch for investigation of the triple murders of Indupur. I know he had ample liking for the journalists. He was also a senior journalist and editor. When I was in Samaj, I had a dispute with the union manager, Dojobhai. As a result, I was driven out from the responsibility of representative of Samaj in Kendrapada. This incident was of 12 years back. In one evening, I met Janaki Babu in his Bhubaneswar residence and said, "Sir, I am no longer in Samaj. Since there is infighting in the management, I have been driven out." Having heard this, Janaki Babu, after thinking for a while, called the editor of Samaj, Sharat Mishra, over phone and said, "It was not proper to drive out Parikita Babu at this old age. Please keep such a dedicated journalist." Having heard this, Sharat Mishra said, "You kindly tell Manu Bhai of Lok Sabha Mandal." To this, Janaki Babu said, "Sharat Babu, you please tell Manu Babu that I have told you to keep Parikita Babu in Samaj." After 2 days of this incident, Sharat Babu called me over phone and informed that, "Parikita Babu, you work as a district representative of Samaj as before. Now I am 75 years old and still working as the district representative of Samaj only due to Janaki Babu." Janaki Babu had always liking for journalists. He was rightly judging the sorrows and problems of the journalists. On his sad demise, there is irreparable loss to the literature, culture, and politics, and irreparable loss to the journalist as well. This is page 18. Can turn to page 18? Can just to see? Can see the page 18? Page 18. This is an article given by him, and with respect to this article, he made a complaint before the magistrate matter. That is page. Page starts at page 9, and the facts are at page 11. At page 11, the fact starts.
Achha, the news item was forged according to him.
Yes, it's a news item. This is not a news item. It's an article given by him. Article published. And when
I am probably saying he never wrote this article.
He says no, never wrote it. But what is the defamation? Well, kindly see section 500. The defamation is defamation. Kindly see 499. Definition of defamation. Section. Whoever by words either spoken or intended to be read or by signs or by visible representations makes or publishes any imputation concerning any person intending to harm or knowing or having reason to believe that such imputation will harm the reputation of such
because
person.
This seems to suggest that he was driven out of Samaj, and it is only because intervention of that former chief minister that was somehow retained in Samaj.
He says that. Whoever published it. This is not new datum. Is his article.
No, he says he never wrote this article.
He says that, but it is not defamatory. Kindly say.
No, if he's supposed to have said in his article that I was thrown out and was put back because of the chief minister, maybe he does not want.
With regard to that, he has to send some objections saying that I have not sent it.
He says that in his complaint, he says that personally.
He said that, well, but he has not filed any document.
No. Just see what he says in page 13. I sent my protest letter.
And all through he says the news item. This is not a news item.
No. But I immediately after coming to know the news item, I personally ran.
News item.
Sir, that is the main point, or you want to miss the main point altogether?
No, it's a news item. And it is an article.
It is the only issue here is whether it's news item or article. Then you're sadly mistaken what this whole case is about.
Yes, my lord, he says,
please read what is this complaint.
Yes. I informed that I had not written or sent the above quoted news item and is a contest of false and imaginary, but he promised to look into the matter. But as no action was taken, I sent my protest to the editor Sambar by fax on so and so, complaining the same news as false and untrue. But gave him the copy of the news item. But in vain, neither protest message was published nor read. But he sent it by the fax.
Sir, he's saying I never wrote this article, and you're publishing an article giving his name. Obviously, he's entitled to protest.
Is this news item?
You're not carrying a correction. You're not carrying an apology. Nothing. If you carried an apology, if you told the public, Mr. So and so says he never wrote this article.
I'll take instruction. Contain history.
No, for what? Instruction for what? How do you carry an article by a person? How do you carry an article?
It is being sent by the.
This is which year? 2015.
Yes, madam.
How is it sent to you by post?
How it was sent?
Then all this will be matters for evidence,
and also
all this will be matters for evidence.
And also
it is sent by a company letter which does not have a signature.
His name is there, and this is not a defamator.
Mr. Sarangi, can your name not be put on anything?
No.
Merely because your name is on something, you will assume that it is written by you. I give you 2 pages, put down below that Mr. Sarangi. You will presume it is Mr. Sarangi who wrote it.
If you will give, then I presume.
Really? I'm sure. I'm sorry. You will be making a sad mistake if you do that. I write anything that you are abusing X, Y, Z, and I put down Mr. Sarangi. You will say, no, Chief Justice has said it, so I'm accepting it. You will in fact protest even louder.
But there is no.
You will say, how did you do it?
There is no abusing matter in this layer.
No. What are you saying? You're suggesting that he got thrown out of Samaj.
No, I'm not suggesting. He says that
what this article is suggesting is that, sir,
I was thrown out, but on the intervention.
Suppose this never happened.
Or the intervention.
This never happened. Then,
I'm Uttara to 465. This is also not made out.
And a matter for trial, sir. You say, as far as petition number 1 is concerned.
At the time of discharge, criminal charge, I'll raise all these matters.
Yes. Petition number 1 is stated to have expired, and therefore the petition, as far as he's concerned, has awaited. As far as petition number 2 is concerned, Mr. Sarangi craves leave to urge all the points raised in the present petition at the appropriate stage in the trial court. The petition number 2 is permitted to do so. The petition is disposed of. The interim order is vacated.
At number 55.
None appears dismissed.
At number 56.
The interim order is vacated. Same this 56 was.
At number 57.
Same order.
58.
Same order.
59.
My lord, in item number 59, I am appearing on behalf of opposite party number 2, my lord. And there is a compromise between the petitioner and opposite party number 2, as it is a matrimonial dispute, and we have filed the compromise petition also.
All right. Counsel appearing for opposite party number 2 confirms that the matter has been settled between her and the petitioner, and a compromise
at flag C, my lord.
Has also been filed at flag
yes,
C. In that view of the matter, to take from the prayer clause. PS case number 35, bracket 12 of 2016, corresponding to CT case number 664 of 2016. In Bhubaneswar, Mahila, and all proceedings consequent thereto are hereby quashed.
Obliged, ma'am.
Deeply obliged, Your Lordship.
Item number 60.
None appears dismissed.
Item 61.
Petition is infructuous, Your Lordship, in item 60.
Infructuous, all right. Disposed of is infructuous.
Item 62.
None appears dismissed.
Item number 63.
May I please, Your Lords? The petitioner is challenging the order of cognizance. But case is prosecution case that 3 persons were standing on the bridge. Suddenly, a police patrolling party consisting of 5 members, they came to the prosecution case. They asked regarding their identity, and it is alleged that all the 3 persons, they started assaulting the police party 5 persons by means of his blow. Well, thereafter, one of the persons tried to run their motorcycle. That is the allegation. Subsequently, they could apprehend all the 3 persons from the spot. And my only confining my case is that 3 persons, the police they sustained a simple injury, and police has submitted charge sheet alleging of 307. I am confining to 307 allegation that and while considering the bail application, SDGM while granting bail also observed. Kindly have annexed the order sheet and annexure 3 while considering the bail application, running page 21 only. Your Lordship, kindly see. Without the ingredients of the there can be no offense on this section. Further, since such intention precede the act, such intention has to be gathered from all the circumstances so far as the investigation reveals that under the circumstances for which the alleged incident took place, as discussed above, it cannot be said that it is a true case of 307. So I am
all this will be at the damage charge, sir.
Charge, but 307 cannot be it is not unnecessary.
You have to argue this at the stage of charge.
That is why case diary was called for and injury report was called for by last order sheet. Your Lordship will see.
Yes.
In the last order sheet, it was my only contention before Lordship.
You can argue this at the stage of charge.
At this time, 307 no question.
If it is a lesser offense, the court will frame charge for the lesser offense. All right. Permitting the petitioner to raise all pleas raised to the appropriate stage before the trial court, the petition is disposed of. The interim order is vacated. All right.
Item 64.
Wait, please, Your Lord. Wait, please, Your Lordship. My Lord, the petitioner is challenging the order of cognizance, that is at Annex of 4, my Lord, for cognizance of commission of offence under 363, 366, 376, 2I, 506.
376.
My Lord.
My
Lord, from the allegation, from the allegations made in the affair, from the 161 statement and 164 statement of the victim, there is no allegation of offence in
so 376 has been stayed for the last 6 years.
My Lord, 161 and 164 statement is at Annex 2, my Lord.
Yes.
That is in Odia, my Lord.
Yes.
By the 161 statement, the victim states that he was in talking terms with this accused. This accused is a brother-in-law, talking terms. Her mother and her sisters asked her to get out from the house, my Lord. She went to the computer center and never returned. And she has explained that from there she went to Baroda, where
what's the age of the victim?
As per
16.
16.
So that's why it's a technical thing, sir. You say permitting the petitioner to raise all the pleas at the appropriate stage in the trial court. The petition is disposed of, the interim order is vacated. Just imagine 6 years you got the rape trial stayed. All right.
Item 65.
None appears dismissed.
Item number 66.
None appears dismissed.
Item number 67.
Your Lordship, in the virtual mode. Hello, my Lord, I'm audible, my Lord?
Yes, please.
My Lord, I just permit to take this ground before the lower court, my Lord. And make
all right, permitting the petitioner to raise all pleas at the appropriate stage. The petition is disposed of. All right, interim order is vacated.
Item 68.
None appears dismissed. Interim order is vacated.
Item number 69.
Same order.
Item 70.
Lordship may dispose of the matter with the liberty to raise the question at the time of
permitting the petition. All right.
Item 71.
Lordship, same
order.
Item 72.
Lordship.
Lordship may allow me to raise all these points before the.
All right. All right. Permitting the petition to raise all the points.
Item 72, sorry, 73. Item number 73.
None appears dismissed.
Item number 74.
None appears dismissed.
Item number 75.
None appears dismissed.
Item number 76.
None appears dismissed.
Item 77.
Memos taken on record. Dismissals withdrawn, interim orders vacated.
Item 78.
None appears dismissed.
Item number 79.
None appears dismissed, interim orders vacated.
Item number 80.
None appears dismissed, interim orders vacated.
Item 81.
Same order.
Item number 82.
Same order.
Item number 83.
Memos taken on record. Dismissals withdrawn, interim order vacated.
Item number 84.
None appears dismissed, interim order vacated.
Item number 85.
None appears dismissed, interim orders vacated.
Item 86.
And the item 86, my lord, the higher offense of charge sheet has been filed, my lord.
All right. So it's infructuous.
No, my lord, I will raise my point at the time of framing of charge.
All right. Permitting the petitioner to resolve the pleas at the appropriate stage.
Item number 87.
None appears dismissed.
Item number 88.
None appears dismissed.
Item number 89.
May I please your lordship? Can taken up next week, my lord. My senior is held up in another court.
What's the matter about? Why didn't you argue?
Matter is challenging the order of the trial court, rejecting the application to recall the 4 witnesses in the trial. That has been challenged before your lordship.
And the trial itself got stayed.
Yes, my lord.
All right. The limited prayer in the present petition is that the trial court has rejected the prayer of the present petitioner to recall 4 of the witnesses for re-examination. Full stop. The petitioners are facing trial under section 302 IPC. Stop. What the witnesses might say could not have been anticipated by the trial court as it has in the impugned order, rejecting their plea. Full stop. A chance ought to have been given to the petitioner to summon the said witnesses through the court process. Full stop. Paragraph. Accordingly, the impugned order dated 16/10/2017 is hereby set aside. The 4 witnesses to whom summons was sought to be issued by the petitioner will now be summoned by the trial court. For this purpose, the matter will now be listed before the trial court on 15 December 2022. The interim order is vacated. Considering that this is a trial of which year?
Trial is
2010.
10-13 years. City number 124 of 46/29.
No. What is the date of the occurrence?
Date of occurrence. The order date.
The trial court is directed to complete the defense evidence within 1 month and dispose of the and pronounce final judgment in the trial within a further period of 2 months thereafter. A copy of this order be sent to the concerned trial court forthwith.
Deep obligation.
Item number 90.
None appears for the appellate. Dismissal on prosecution.
Item 26 was claimant's appeal for enhancement. Last occasion also that council appealing for the Odisha State Road Transport Corporation was not there. He also directed him to serve him one extra copy. I was last night also I was trying to contact the lawsuit.
You are for the appellant?
Yes, I am for the claimant's appeal for enhancement. May I pray you also keep it next week. By Monday I will give a written notes of argument also. The matter is twice remanded, initially awarded rupees 1,48,000. Subsequently,
Even today, all right, you just cancel the earlier order. Mr. S.K. Joshi, counsel the appellants, informs the court that he had served a copy of this appeal on.
No, I could not able to contact him over the number. So keep it by Monday. I will try to contact him and give him a
That
copy.
he was unable to contact the counsel for the respondent, Mr. K.C. Mr. B.K. Sahu.
B.K. Sahu.
Mr. B.K. Sahu. He states he will positively do it before the next date. List before the roster bench on 19th December.
19th
December.
As you also.
One more matter in the additional specialist. Additional specialist, item number 1, CRLMC 1658 of 2012.
May it please your lordship. And on the last occasion, the London State Council was to take instruction whether sanction has been obtained in the meanwhile or not.
Same thing. You say till despite an adjournment granted, adjournments granted on 24th June, 5th August and 26th August 2022, counsel of the state is unable to inform the court whether sanction has been accorded by the state for prosecution of the petitioners. Full stop. So what is your sub? Without sanction, prosecution cannot proceed.
This is the case involving an offense under section 354 of IPC. And Malad section 197 CRPC itself explains that in a case which involves section 354, the sanction is not required, Malad. It is in there in section 197.
Let's see that.
The explanation.
Where is it, sir?
Explanation. 197 1B, the explanation to subclass B. For the removal of doubts, it is hereby declared that no sanction shall be required in case of a public
Under
servant.
section 354.
That's it.
All right.
This is a 2000.
So let it proceed, sir. It is pointed out by counsel appearing for the opposite party that in terms of the explanation to section 197 bracket 1 of the CRPC, no previous sanctions shall be required where the offense against the public servant is inter alia under section 354 IPC. First of all, the present case is one where cognizance is taken against the petitioners for that offense. Paragraph. Consequently, the court sees no reason to interfere at this stage. The petition is dismissed. The interim order is vacated. Over. All right.
For orders, item number 1.
My lordship, my lord. Last time, my lordship called for records from the jail authority.
Well, I got the instruction. Plus, the appellant was admitted on 2nd of July 2022, since he had developed.
He could not work properly.
Yeah, so well, that's why I leave it to him.
Yeah. You see, the present application for regular bail is by the appellant.
My lord. 74 years old lordships.
You say while IA number 286, sorry, 1088 is for interim bail, right?
Please, my lords. 1088 of 2020.
2022 for interim bail. 287, I think, is for
606 for regular.
606 of 2022 is for regular bail. Right. The appellant is admittedly 75 years old.
My lord.
Stop. The report of the IIC Telco EPS states that he was hospitalized for left side hemiparesis bracket ischemic in the DHH Kionjar. Stop. Although he has been discharged, it is stated, open quotation, but he could not walk properly due to hemiparesis disease, unquote. Yeah, the appellant has been in custody for more than 10 years. Full stop. Keeping in view, and full stop. It is unlikely that the present appeal, which is of 2019, will in the regular course be listed in the immediate future. Keeping in view all the above factors, the court directs that the appellant be enlarged in bail during the pendency of the appeal, subject to the satisfaction of the trial court. The applications are disposed.
Oblige, my lord.
All right.
Oblige, my lord.
So they want extension of time by 3 months.
Item 1.
Please, my lords.
Yes, my lord, we should allow.
All right. You see,
Grateful.
in this application, it is explained that although the process of considering the representations of the petitioners and giving them a hearing has already commenced, the exercise might take 3 months more time to complete. Stop. Paragraph. Keeping in view the factors set out in the application, the court extends the time for completion of the hearing and passing a reasoned order up to 6th February 2023, and for the order to be communicated to the parties not later than 13th February 2023. The application is disposed of.
Grateful. Item number 2.
Application hard earlier for reduction of the demand to be calculated from 14th of December
Yes.
2018.
Correct.
Why I am saying, my lords? My lords, lords will kindly see in my affidavit 13671 of 2022 in this petition, I have enclosed the order of the company appellate tribunal.
Right.
Lords will kindly see this order of the NCLT was stayed by the appellate tribunal. Lords may kindly see on 28th of November 2017.
Right.
And again the stay was extended, and stay was extended on 15th of December. Finally, the appeal was dismissed by the appellate tribunal by the annexer 12 to my writ petition 271, or at page 271, it was dismissed, my lords.
Right.
Now, therefore, the management, since the order of the NCLT occasion for the management to take into control, it was only handed over after the. Now, this fact, unfortunately, I could not bring to your lordships' kind notice in the earlier judgment delivered by your lordships on 82, that is in 8259 of 2021, which is identical. That was for the drawing water from the river. This is for the groundwater. So they have filed a counter affidavit, and they say that the judgment which was rendered in my favor has not been challenged by me. Secondly, they say in the counter that I have a revised plan has not been submitted before the committee of creditors. Now, if your lordship will see the
so the demand has to be stayed till 18 then.
18. The demand will be calculated from December 14, 2018 onwards. And I have deposited extra 36 lakhs. I want to be adjusted from the regular bill. That's all what I want.
My lords, let me, my lords, take first, my lords, to the public notice that was issued. My lords, the IBC proceedings has a particular rigor. Let me, my lords, take my lords to the notice, public notice that my lords will find at page 52 of the writ petition.
Yes.
Please, my lords. As this is just to show what is, my lords, before the COC and what, my lords, comes before the adjudicating authority. My lords may see relevant particulars. Serial number 9. Last date for submission of claims, February 13, 2017. So, my lords, whether I am an operational creditor or a financial creditor, my lords, I can only submit my claims which were due before, my lords, February 2017. February 13, 2017. Thereafter, my lords, whatever claims comes, that is not, my lords, with respect before the COC, and that was not, my lords, for adjudication before the adjudicating authority, which is the NCLT and the NCLA.
Yes.
Now, my lords, the
Lordship may
resolution-
kindly see
My lords,
annex.
my lords may kindly let me finish my.
Okay, okay.
My lords,
Very
the NCLT, the resolution plan that was submitted, my lords. Let me, my lords, take my lords to page 128 of the resolution plan, where they have set out the statutory liabilities which the COC has debated and voted upon. My lords may find it at 128, page 128. 3.2, statutory liabilities and other legal liabilities.
One.
My lords may see that does not include anything to do with water tax, my lords. And in any case, my lords, these are claims which were due before February 13, 2017, because post that the COC will not take any claim. Thereafter, my lords, the NCLT in its wisdom has frozen the commercial wisdom that was shared by the COC and that was approved in favor of the resolution applicant. That date is, my lords, 7th of November 2017. Now, my lords, in the previous judgment that, my lords, the order here for modification relies on the judgment delivered by my lords in writ petition 8259 of 2019. I have, my lords, quoted the paragraphs. My lords have noted in that the NCLT has, let me, my lords, read that paragraph for the benefit of. That is in my reply as well. My lords may see page 2 of my reply. Page 2, para 3.
Yes.
Yes, my lords. Foot of the page, my lords. The relevant portion of the order dated 21/6/2022 in WPC so and so is extracted here. In the meanwhile, the resolution application of the promoter of the petitioner company was approved by the Committee of Creditors and further approved by the NCLT by its order dated 7th
So what was
November.
not noticed was that it was stayed. So
Yes.
once the 7th November is stayed,
Yes, my lords. Yes.
so the stay gets lifted only on 13th December.
Yeah.
So in that last paragraph,
Please, my lords.
in fact, this is what he's saying.
Yes.
Although we noticed that the NCLT had dismissed the appeal on this date,
Please,
we didn't notice it was stayed.
Please, my lords.
And because there was a stay, he could not have taken control of the company.
No, my lords, my lords, therefore, my lords, all my lords, this judgment and the order that has been passed now relies on Ghanshyam Mishra. Now, my lords, the Ghanshyam Mishra judgment. Now, my lords, let me read what Ghanshyam Mishra says with regard to what claims can be extinguished and what does not get extinguished.
Anyway, the main writ petition is still pending, is it?
Yes, my lords. That
They
is
may
pending, but my
petition-
lords, my lords, the thing is there are
He has already paid in excess.
In excess, my
He
lord.
has already paid.
Yes.
What he's saying is that excess he
Only
has paid
13
to the
that's the
adjustment
amount
of future bills.
my lords, he is saying that from 13/12/2018, the
He's
due
liable.
to be paid.
He says he is liable after
liable.
13/12.
He's liable.
Yes.
But now he has paid for the period 7th November 2017 to 13th December 2018.
that
He
is
has also paid that amount.
Yes, my lord. My lord, that is the amount that is due to us and that has to be paid, my lords.
No, but if there is a stay of it, the question is, will he get the liability or the previous entity get the liability?
Previous one, my lord. And
My
No, is there any
no, my
previous entity is the question?
No, my lord.
no, there was no, my lord. The section 29A came into existence in 2019. Prior to it, my lords, the promoter was entitled to give the resolution plan. And accordingly, the resolution plan submitted by the management, the promoter, was accepted. And to rebut the argument of my learned friend, Lordship will kindly see the resolution, the revised plan was also placed before the Committee of Creditors. Lordship may kindly see page 63 of my writ petition. In the said meeting of the COC, Srei objected to the resolution plan of Mr. Agarwala on various grounds. Mr. Mahesh Kumar Agarwala, the present promoter of the company, sought modifications in his resolution plan, full stop, the COC by 78.53% of voting share of the financial creditors of Sri Metallics Limited approved the modification proposed by Mr. Mahesh Kumar Agarwala in his resolution plan. Sri has submitted an addendum to the resolution plan. The COC agreed to consider the addendum submitted by the SAI while considering the plan. And the appellate tribunal also, Lordship will kindly see, has considered this, the revised plan.
No, does that revised plan include these groundwater dues?
Yeah, groundwater dues, my lords. Lordship, they did not submit. Lordship, I'll take only one letter from the resolution, interim resolution applicant. That is, my lords. Lordship will kindly see. That is Annexure 8. They did not submit their claim, my lords, in the proper format. Regulation 7 of the committee of that, IBC says that you have to submit your claim within the format prescribed. The law requires that thing to be done in that manner. They did not submit. And what they submitted to the resolution applicant is that I'm giving my letter, that is 55 to 60. That is why, so they could not, the resolution, the IBC says that this has to be in support of the affidavit by an this verification. You just cannot do it as a, it is very difficult to the resolution personnel, personnel to verify the claim. They did not submit. Therefore, the judgment of the Supreme Court said that unless the claim is submitted, the information memorandum as per section 26, they have to contain the information, and that could not be verified. And that should not be the what the Supreme Court said, my lord, there should not be any hydroheads.
The question is this an admitted claim or it's not an admitted claim?
No, this is not an admitted claim.
Because Miller, the drawing order was unauthorized, and that was the
no, but did you actually submit a proper claim? Part of that resolution plan.
Therefore, Millards, pursuant to my lord's order, the date for consideration of the arrears.
Then you lose up to, you see, the point is, if it has been stayed and the stay is lifted only on 13 December, your dues will start running from that date.
Millards, but Millards, may I read Millards Ghanshyam Mishra? What Ghanshyam Mishra says as to when does it freeze, Millards? Ultimately, Millards, what is being stayed? The stay is the adjudication of the COC on the claims, Millards. That is, Millards, and the resolution plan there too.
No. So the person taking over can't take over as long as the stay remains.
Please, Millards. Please, Millards. But Millards,
so why would he be reliable for a period prior to his taking
Millards,
over? As simple as that.
Millards, there are two answers to that. One is, Millards, if I may just read Millards Ghanshyam Mishra, para 93. I've given the booklets.
Yes.
Para 60 may kindly be seen, my lord.
93. Let me read 93.
Okay.
Well, this is a
you
page,
have to come 93 through para 60.
Page 714.
Right.
Yes. Please. As discussed here in above, one of the principal objects of the I&B code is providing for revival of the corporate debtor and to make it as going concern. The I&B code is a complete code in itself. Upon admission of petition under section 7, there are various important duties and functions entrusted to RP and COC. RP is required to issue a publication inviting claims from all the stakeholders. He is required to collect so and so. The resolution applicant submits their plans on the basis of the details provided in the information memorandum. The resolution plan undergoes deep scrutiny by RP as well as COC in the negotiations that may be held between COC and the resolution applicant. Various modifications may be made so as to ensure that while paying part of the dues of financial creditors as well as operational creditors and other stakeholders, the corporate debtor is revived and is made an ongoing concern. After COC approves the plan, the adjudicating authority is required to arrive at a subjective satisfaction that the plan conforms to the requirements as are provided in subsection 2 of section 30 of IRB code. Only thereafter, the adjudicating authority can grant its approval to the plan. It is at this stage that the plan becomes binding on the corporate debtor, its employees, members, creditors, guarantors, and other stakeholders involved in the resolution plan. The legislative intent behind this is to freeze all the claims so that the resolution applicant starts on a clean slate. It's not flung with any surprise claims. Now, my lords, what does it say?
It really helps him.
No, my
In
lords.
fact, the more you've emphasized, it's very clear that
Yes, my lords.
he has to start on a clean slate.
Yes, you have to submit the claim in a clean slate, but there's a qualification. That is my humble submission. The qualification is that the claims are the claims that is.
You don't even have a claim, so you're in a very
no, my lords.
worse position.
No, my lords. The claims that is before the COC.
Your claim was not before the COC.
No, my lords. No, my lords. I'm not saying that. I'm saying the date is, my lords, 13th of February 2017.
No.
Beyond that, my lords, no claim can be. And this is, my lords, a claim which is from 7th November 2017.
No, you're mistaken. Whatever claims were there validly before the resolution professional, that will be admitted. The person taking over will be told these are the claims you have to take over, and that's how he takes over.
Yes.
If there is no claim at all before the resolution professional, that claim cannot even be recognized.
Yes, that is
so. The day he takes over is 13th December 2018. It is not 7th November 2017.
No, that is the thing, man. Millards, my issue is now this is an essential supply that is given, so under the moratorium period also that is exempted. My lords, my lords may kindly appreciate this point. The point, my lords, is that from 7th November 2017 onwards, there was no forum for me to agitate my claim as well.
Because you haven't, in fact, you did not submit your claim at all.
Because we submitted.
It was not an admitted claim.
It was not an admitted
where's
claim.
The question? Where's the
So
question?
therefore, my lord, I am saying now that there are two eras, if I may put. One is the CIRP era, which ends on 7th November 2017.
No, it doesn't end. It gets postponed till 13 December.
13 December.
You're mistaken on that. Once it is stayed, it does not come into operation till the stay is lifted.
Yes, my lord, because
so
what
the date becomes 13 December.
My lords, and what happened before the NCLAT is that the resolution applicant, the successful resolution applicant made some inter se adjustment within, so it did not relate back to the COC.
The point really is the liability of the person taking over does not begin till the stay is lifted. As simple as that.
But then there is a vacuum that from 7 November.
In your case, there's anyway a vacuum because you never submitted a claim at all.
Yes, but that gets freezed from 13th November, 13th
December
February
2018. The freezing itself gets postponed because there is a stay. That's the point. The freezing gets postponed.
But for essential supply of goods, which includes water.
Still proceed against the promoters, maybe. I don't know. If that's the
because under 14.2a, if I may read 14.2a, and with rule 31 says that water is an essential supply, and to keep it as an ongoing concern, water has to be drawn. And therefore, an agreement has also been entered into post 7 November 2017.
All right. You see, this court has heard the submissions of the counsel of the parties. The point that arises for consideration in the present application is whether the actual liability of the present petitioner, which took over from the erstwhile company, commenced on 7th November 2017, the date that the National Company Law Tribunal approved the resolution plan, or at a subsequent date, that is 13 December 2018, when the National Company Law Appellate Tribunal, (NCLAT), vacated the stay it had granted on the resolution plan and the order of the NCLAT, and finally approved the plan by dismissing the appeal. Question mark, paragraph. As regards the what dues, that was the
river drawing water from the river dues.
Yeah.
This is for the groundwater.
As far as the dues of the
Groundwater.
present petitioner for drawing water from the river was concerned, this court dealt with that issue in an earlier writ petition filed by the present petitioner, that is writ petition civil 8259 of 2019 bracket Messrs. Sri Metallics Limited was State of Orissa bracket, and passed an order on 21st June 2022, the relevant portion of which reads as under. Take from the reply of the respondent the extracted portion para 3, paras 5 and 10, unquote. In the above para 5 of the order dated 21st June 2022, this court noticed that the resolution plan approved by the NCLT by the order dated 7 November 2017 had been stayed by the NCLAT. No, did not notice that it had been stayed by the NCLT, but only noticed that the NCLAT had dismissed the appeal on 13 December 2018. So therefore, in para 10 of the above order dated 21st June 2022, this court observed that there would be no claim for the period between December 2009 up to 7th November 2017, the date of approval of the resolution plan, as regards the river water dues were concerned, paragraph. However, the fact remains that the NCLAT did stay the order dated 7 November 2017 of the NCLT and vacated it only when it dismissed the appeal finally on 13 December 2018. Paragraph. Learned counsel for the state referred to para 61, para 93 of the judgment of the Supreme Court in Ghanshyam Mishra and Sons Private Limited versus Edelweiss Asset Reconstruction Company Limited, 2021 9 SEC 657, where inter alia it has been observed as under this after COC approves the plan, A to A. Paragraph. As the court views it, the above observations of the Supreme Court in Ghanshyam Mishra and Sons Private Limited Supra reinforce the submission made by the petitioner here that its liability could not have commenced prior to 13 December 2018, since the order of the NCLT approving the resolution plan stayed by the NCLT till then. Stop. In other words, the freezing of the claims against the company being taken over by the present appellate continued beyond 7th November 2017 and went on till 13 December 2018. Paragraph. As it transpires pursuant to the order dated 26 September 2022 of this court, the petitioner has already paid the dues for groundwater from 7 November 2017 onwards itself. Stop. In other words, it has made an excess payment for the period between 7th November 2017 to 13 December 2018. Full stop. It is this excess payment that a petitioner seeks adjustment of against future bills that may be raised for consumption of groundwater or river water. Groundwater. Full stop. In view of the above position emerging as a result of the stay order granted by the NCLAT of the NCLT's order dated 7 November 2017, which was lifted ultimately only on 13 December 2018. The liability to the petitioner would commence only from 13 December 2018 onwards and not earlier. So therefore, the payment made already by the petitioner of the dues of the groundwater dues for the period 7 November 2017 to 13 December 2018 would now be adjustable, would not be treated as an excess payment, adjustable against future bills raised by the state against the petitioner for groundwater. Stop. The order dated 26 September 2022 of this court will stand modified accordingly. The application is disposed of.
Right.
15 December.
15 December. Obliged, madam.
Supplementary list for orders, item number 1.
The corrections as pointed out by the office. Right.
Item number 2.
Here, in fact, Lord, this review I have been compelled to file because the HO was listed and of course disposed of. There was some mistake in the cause list for which
Ground A, Mr. Pal, ground A.
there was I could not appear. I am also prepared to submit on the merits of the appeal.
No, I have an objection regarding the maintainability. I filed my preliminary counter affidavit. I've given him a copy.
Yes, then
The power that was exercised under the intra-court appeal, latest patent appeal, or was under the latest patent of the Patna High Court, as understood by the Orissa Government Order 948. Now, the power of review is not available. Your Lordship knows it's not an inherent power, like recall. It specifically has to be provided. Now, that is not provided in the latest patent. So CPC 147 is not applicable here. So 47 application in a latest patent is not maintainable. So that judgment I am giving, my lord, says
Patel Narsi.
My lord,
I
have quoted that out.
This is Mahapatra.
Yes, ma'am.
He says the review itself is not maintainable.
So according to you, recall is maintainable. Will recall the order?
Exactly. That is
They has to withdraw and file a recall application.
Because without
I am not advising.
Mr. Pal, please try to understand the principles of natural justice. The other side, he was there, his wakalatnama was there. It's a mistake on the part of the registry. His name was not reflected. The order was passed in his absence without hearing him.
The exercise here is of review. So 47 is not applicable. The difficulty is this. He let me withdraw it, then file. There's no difficulty. Because exercising a review power in a latest patent would be absolutely against the law. Because your lordship will see para 4 of the judgment.
We can recall the order. Recall passed. Order passed, we can recall.
Not in a review application.
Oh, it is open for him if he comes up with a IA in that.
Let him come up with an IA. This review is not maintainable.
Let him file an IA in the HO.
Yes, let him file.
Just paragraph 26 of that judgment. That is, I am unable to provide a copy to Justice Mahapatra, but I am just placing it. That is 97/2004 CLT 421. It's the judgment of the Honorable Apex Court.
This is a different thing. This is not a fraud, sir.
No, I am not quoting the fraud. Kindly, I am reading the entire paragraph. Small paragraph, very small.
You want to say review petition is maintainable?
No, review, the power is inherent.
You file an IA, sir.
Let him file an IA.
You file an IA. Withdraw this and file an IA.
Let's make convert it. I don't.
No. How can he
file?
Let him withdraw it and file. There's no difficulty. Because power of review is not available.
It's only change of nomenclature. It's a change of nomenclature only. If my learned friend's argument is accepted also. Again, same exercise I have to do it. It's a
well, also he has
referred
to High Court of Orissa.
High Court.
He has referred to petition, not Orissa.
is itself.
That is okay. That is all.
Fine. I'm just,
Hypertechnical.
He should
I'm just
correct it.
placing the
So
word.
if he convert this into an IA, what happens?
Yes, no problem.
let him
No, we'll just ask the registry to register it as an IA and place it.
Yes, then I will file my objection to that.
All right.
Yes,
You say
no
a
problem.
preliminary objection has been filed to the maintainability of the review petition, relying on the judgment in Patel Narshi Thakurshi versus Sri Pradhiman Singh Ji, Arun Singh Ji, 1971, 3 SEC 844, paragraph. Mr. Monty, learned counsel appearing for the petitioner, then offers that the present review petition itself be registered as an interlocutory application for recall. Paragraph. The registry is directed to renumber the present petition as an IA for recall and place it before this bench on 11th November.
11 mana 18, maybe 18.
All right, on 18th November.
Because I'll file my.
Reply now be filed
Yes.
by the
Next date I'll file.
respondents on the basis that the present petition would now be an IA for recall.
Great.
All right.